I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my pleading co-host, Brett.
Hello, Alice. Always pleading for forgiveness. Never permission.
There's lots of uses of the word pleading, but obviously today we're talking about something that comes up in many cases. I think we've talked about it kind of around it, but we've never really covered the mechanics of plea agreements. Whether you have a right to it, what's in a plea agreement, how to effectuate a plea agreement, what the judge's role is, and whether it's a good thing or bad thing in our justice system. So all big questions to cover. You guys have asked them before, so we are spending today's episode to walk through some of these issues so that when you hear it thrown out in one of the many cases you may follow, oh, so-and-so pled guilty, or so-and-so is holding out for a plea agreement, or so-and-so never was conveyed by their attorney that they had a plea offer. What do those things mean?
Yeah, and one thing that we've tried to disabuse people of, which I don't know if we've succeeded in this or not, is that pleas are very well thought out things. They're not things, for instance, that you typically do at arraignment. When you show up and the judge asks you for the first time, how do you plead? And you say not guilty. And pretty much every case, whenever that happens, particularly if it's a case where we all know the guy did it. I mean, take like a mass shooter or something who gets arrested and they plead not guilty. There are always howls from social media. I can't believe, how can he plead not guilty? And it's because that's what you always do. Because while a plea in some sort of deep philosophical sense is about admitting guilt or not, it's also a very important mechanical aspect of the judicial system and the justice system, and moving from being accused of a crime to being punished for it. And once you plead guilty, you lose all your leverage. So if you are the defendant, the one thing you have, or one of the few things you have, is the ability to plead guilty. And in doing so, to save the state a whole bunch of time, energy, effort, resources, and the possibility of losing. You know, in the back of a prosecutor's mind, no prosecutor is afraid to try a case. You can't do this job if you're afraid of trying a case. But in the back of your mind, you're always thinking, man, we got to get this guy. I really hope we win this one. And no matter how strong your evidence is, the wild card of a jury is always out there. And you know there's a possibility that if you walk into that courtroom to try a case, you could lose it. So when a defendant is willing to accept guilt, it's pretty much always a win for the state in every way. So it is a piece of leverage. And that's one reason that this whole system of pleading guilty is more than just deciding to admit you did it.
And let's make clear something, too, as well. A defendant always has the right to plead guilty, just like they have the right to plead not guilty and go to trial. But a guilty plea is different than a plea agreement. So while the defendant always has the right to choose whether to say, I'm guilty or not guilty, a plea agreement is a signed contract with the government that lays out certain considerations for the guilty plea, essentially, certain rights that are given up on both sides of the V. Plea agreements are not a right to any defendant. Plea agreements have to be offered, and they do not have to be offered. But even if a prosecutor doesn't offer a plea agreement, the defendant still can plead guilty. Oftentimes they don't want to because they want something in exchange because of that leverage they hold for being able to plead guilty. So just know, while oftentimes they may go hand in hand, they are actually two different things. And plea agreements are not a right that every defendant has to.
And, you know, there's this sort of feeling out there, I think, amongst people who've never been involved in the justice system, of sort of, why would you plead guilty? Why not just take it to trial? And I think the average person, if they are given the hypothetical, if you're charged with a crime, what would you do? They would say, I'll fight it. I would fight it. I would go to trial and I would testify, right? That's what everybody says in the abstract. But the fact of the matter is that's usually not what happens. And there are a few things that lead people to plead guilty. One of them, and it's easy to be cynical in this world, but one of them is actually accepting responsibility for what you did, which on occasion happens. There are people who want to accept responsibility for what they did. There are people who've been on the run for a while, who've experienced living with what they did and have felt the weight of that on their conscience and actually want to go ahead and get this over, plead guilty. And some of those people, we're talking about this in sort of the context of you've been indicted or you've been arrested. There are occasions where the person pleads guilty before they've ever even been charged with anything. They basically show up with an agreement with the prosecution, and there's an information, which is another way of charging people that you do without an indictment, that you can agree to do if you're the defendant, and they're charged, and then they immediately turn around and they plead guilty to it. So that is one reason people do it, just actually feeling bad and wanting to take responsibility for what they did, and that can have some other advantages to it as well. The more readily you accept responsibility, the more the judge is going to take that into account. People always ask us, do the statements that the defendants make during the sentencing, how much effect do they have? And I at times think the only effect it can have is to make the judge give you more time. I'm pretty convinced of that there's nothing you can say at the sentencing that's going to change the judge's mind, because I think most judges believe in the whole show me, don't tell me. And doing things like accepting responsibility as soon as possible shows something. It shows that you may be more amenable to being rehabilitated, for instance, which is something judges really like to see.
And, obviously some people can be very good liars, but, Brett and I have both had examples where we really do see real remorse. There have been many times, especially I will say in the white collar crimes. And I say that because oftentimes and so these are people who probably commit a lot of fraud or write false prescriptions, for example. They may hold medical degrees and they're using that position of power to exploit what the status they have in society. When we catch them, we haven't indicted them, we're talking to them. Oftentimes I see their face just like flush, like they were like, I've been living in fear of you guys coming for 5 years. I'm so glad you're here now. And we've even had people come in after people within their conspiracy are getting indicted and they're like, you haven't caught me yet, but man, I can't sleep. I haven't slept in years. Like, I just got to come clean. I mean, think about, I know that would probably be me. I'd always be looking behind my shoulder. Every time I walk into a store, I'm thinking, is the SWAT team going to show up and just take me down in front of all of my peers, in front of all my coworkers, in front of my family? So that is a real weight that people take on when they are running from the law. So we see that instance, and that is a really powerful reason for a lot of people to actually clear their conscience, because they believe in a higher power. They believe in their conscience itself, just to be able to sleep at night, be able to live with themselves. They want to come clean. And the second thing in terms of accepting responsibility right away is that they kind of know, like they've been waiting for the law enforcement to like knock on their doors, and they wanted to get away with it as long as they can. And it's almost like a game. And they're like, yeah, you caught me. I'm not going to fight it. That's absolutely what I did. And those people tend to have pretty long rap sheets, and they're not afraid of the system, but they also have been through the judicial system enough that they know when to fight and when not to fight. So there's lots of reasons that people have personally for pleading guilty that have nothing to do with coercion. I hear that a lot, where it's like, well, there's no real choice of the person. They had to plead guilty because of the break in the sentence they were going to get or something like that. They may or may not get something like that. Don't discount the mental load that comes with running from law enforcement.
Now, having said that, another reason you plead guilty is because the evidence is so overwhelming that you really do feel like you have to plead guilty. And I think one thing that's important for everyone to remember, those of us in the true crime space, we often see the extremes. I mean, the cases that are interesting to you out there, probably not your run-of-the-mill, drug deal or felon in possession of a firearm or insurance fraud. It's some murder where there are no witnesses and all you have is some cell phone data and some incriminating statements and maybe a little bit of forensics. And so they're very intriguing mysteries that grab you for the same reason that fictional mysteries grab you, because there's a question about who did it. It's all who done it, right? The vast majority of cases are not like that. Most cases, the person is very obviously guilty. The evidence is massively stacked against them. I mean, that's just reality. And for those people, when they are arrested, they know, I am going to go to prison. There's no question. It's like if you guys have seen National Treasure, and there's that scene where Nicolas Cage is talking to the FBI agent, and he's like, I would really rather not go to prison. And the agent's like, well, somebody's going to prison. Well, in these cases, if you get arrested, you're probably going to prison. And it goes back to that whole, you have to start thinking about sentencing. You have to start thinking about it very soon.
And because of that overwhelming evidence, that's why typically you'll see arraignment, which is at the very beginning of a case, right? No discovery has really changed hands. It's actually in the prosecutor's interest to get discovery over to the defense as soon as possible. They should, because if they've reached the point where they can charge someone, their investigation pretty much has wrapped up and they should have discovery ready. The reason it's in our prosecutor's interest to turn that over is once the discovery is turned over to the defense, they're able to see the strength of your evidence, and that's when negotiations really start. Typically, you're not going to have real meaningful negotiations before discovery because the other side doesn't know what they're working with. Maybe there's some blurry videos, or videos are missing, or, there's conflicting testimony, or the witnesses are really weak witnesses. In that instance, you as the defense may assess, you know what, I have a fighting chance. This is not that strong of a case. I'm going to hold out a little bit longer. Or you see the case and you see just how strong it is against your defendant. You're going to advise them, hey, we should start talking about a potential plea agreement here.
Especially if any of the charges that are on you have mandatory minimums. Because if you have a mandatory minimum, that's the worst, because then it doesn't really matter what arguments you make in front of the judge or how contrite you appear to be or anything else. You're going to get at least whatever. So if you have multiple charges and one of them has a mandatory minimum, if you can plead guilty very early and be very helpful to the government in exchange for dropping that charge, even if other aspects stay the same, say the maximum penalty you could get stays the same, and maybe in most jurisdictions there's a pre-sentence investigation that's done into you where some probation officer gathers all of your history, everything you ever did, every crime you ever committed, every time you were ever arrested, and according to formulas for different jurisdictions, a sentencing guideline range is provided to the judge. So the judge knows, similarly situated defendant, this is about what they would get. Well, even if that doesn't change, the mandatory minimum falling away can allow the judge a lot more discretion than he would have otherwise. So that can be something that affects you, is what you did and what charges you're facing. The other thing could be, do you have any constitutional claims? A lot of times, defense attorneys will come to us and they'll say, look, this is a plea if we don't win the suppression motion. So I'm going to bring a suppression motion. That's really where the fight's going to be. If we win that, the case may go away altogether, or we may feel like we can go to trial. If we lose that, we're going to be pleading. And so then you see the suppression hearing really becomes the trial. And it really comes down to, if that evidence stays in, there's going to be a plea. If not, it's going to go to trial. And I hope you're seeing, why are there so many pleas? And we're going to talk about how many there are later on. But the reason for that is because there's all these reasons, all these steps you kind of have to get through before you would even consider going to trial. Looking at how much evidence is against you, deciding your own state of mind. Do you want to go through a trial, or do you want to accept what you did? Or thinking about the sentence that you're going to get, thinking about whether or not you have any constitutional claims. These are all things that are going to come into play. And then, of course, there's whether you have some information that might be helpful.
Yeah, absolutely. And so we've gone through kind of the steps of a case before, and the suppression point is a really good one, because you can imagine if there was a search and seizure of someone's car during a traffic stop, and during that traffic stop is when they found guns and drugs illegally, and he was a felon, so he couldn't have guns or drugs. But if they contend that the search was unconstitutional and they seek to suppress, the fruits of this unconstitutional search, and they win, no longer do you have guns or drugs. How are you going to win government, a charge for felon in possession of a firearm and possessing X, kilos of cocaine, for example. That becomes, in that case, don't plead guilty. That case likely will be dismissed by the government in that instance. So you can see how an entire case could hinge on something like a suppression motion. And that's why once the discovery is reviewed by the defense, they're going to make decisions pretty early on because they don't want to drag this out for their defendant, especially if their defendant is in custody. Not every criminal charge requires a defendant to be in custody. But most of the violent ones, I think really just about every violent crime, requires most defendants to be in custody. So their client is sitting in jail. So they're going to want to file that suppression motion. They're going to want it argued. And the judges move those along pretty quickly. And Brett's really right about this, where this kind of turns into a trial. You call witnesses. Things come out in these suppression hearings that you may not know previously from your investigation. And that may change the entire case. And that, in some cases, is what the defense is trying to do. Okay, let's test out just how strong your witnesses are. Let's get those, that girlfriend who said that she saw the drug deal go down, get on the stand. See what she has to say. Does she crumble under cross-examination? Because if she does, even if they lose the suppression motion, they're assessing the strength of your witnesses. And it becomes like a chess game. Or they see how good your witnesses are and they're like, you know what? They're even better than they were in the police report. This is not going to go well for my case. So this is all a trial, essentially, for the defense to assess whether they want to move forward and how everything plays out in court.
And it can actually, you think of the suppression hearing as either the defendant's going to win it and the evidence goes away, or he's going to have to plead guilty. And I've told this story before about a suppression hearing I had where in the middle of the suppression hearing, we found out that we had not given all the discovery to the defense because there were these photographs that nobody knew existed until the middle of the defense is cross-examining the officer, and there's just something obviously wrong. We've got all these photographs, but we're missing something. You could just tell something's missing here. Like something happened in between photograph 1 and photograph 3. And it turned out there was a photograph 2. And so we had to deal with that in the middle of a suppression hearing. We ended up winning the suppression hearing, but it was one of those things where, well, now, this is going to be a bit of an issue at trial. So we were less inclined to go to trial because now we're going to have to deal with that. Because defense attorneys are really good at making a lot out of nothing. So the fact that this came in late was something that they would have been able to cross-examine the same officer on when he was on the stand. And, that just planting that seed of doubt in the jury's mind. Oh, they're hiding something. Well, if they're hiding this, what else are they hiding? And you'll see this in every case. People are watching the Karen Reed case on the gallery, and they're talking about how the defense attorney keeps asking questions about things that don't matter. But the point is, there are things that don't matter, but they're little mistakes that were made along the way. So they made little mistakes along the way, and what he's going to do is say, those are the ones we know about. What are the big mistakes we don't know about? That kind of thing. And so that guy ended up getting a more favorable plea deal because we didn't want to go to trial. He would still want to go to trial, and we didn't really want to. So the suppression hearings can have a big effect. It's one reason we talk about how you don't really want to have a preliminary hearing if you can avoid it, because the defense is going to see all your cards. You're going to put all your cards on the table. They're going to learn a lot about you and your case. And so a lot of times you don't want to do that. It's the same thing with suppression hearing. The other thing that we mentioned briefly is, and this comes in a lot, one reason you want to plead guilty is because you want to leave your evil ways behind and join Team America. You'll be shouting USA, USA all the way to the courthouse because now you're going to be a witness. You've got evidence against maybe somebody who's involved in the same crime. Maybe you're part of a drug distribution ring and now you can testify about all the other people, or you're in the mob or something like that. Or you have information about something completely unrelated. And if that's the case, then you have really a huge advantage because there's a lot of things that you can get for that. You can get time off your sentence. We mentioned those mandatory minimums before. You can actually go below a mandatory minimum if the government makes certain motions based on your assistance and what you're willing to testify to. Immunity is something that doesn't come up as much as people think, or it does in one way and it doesn't in another, because there are two types of immunity. There's use immunity, and the way that works is, we've talked about proffers before. So if you're going to get acceptance credit and assistance credit, you have to come in and tell the government everything. You just got to lay it all out. Now, you're given immunity for that statement, use immunity, which basically says anything you tell us here, we can't use against you in some future case. So if this ends up not working out and you go to trial, we can't use it against you with certain exceptions. That's use immunity. That is very common. The one that's not common is something called transactional immunity. That one actually, you've got to get approvals all the way up the chain to do that. We talked about this in the Leo Schofield case, actually. If you're going to be given immunity for the entire transaction, for the entire crime, for whatever you did, that's a big deal, because once you get that, there's no going back. Whereas with use immunity, if you get that and then you decide to go to trial and you lie on the stand, then what you said actually can be used against you. But transactional immunity is very broad, and it's a very rarely used thing.
And that's a really good point. So when people do join Team America, and by the way, we really do call it that, just colloquially, it's not quid pro quo, right? Because we don't know what you're going to say. We don't know if it's useful. This is why we have a lot of jailhouse snitches. They hear something, in their jail cells, and they're thinking, wow, I know who killed John Benet Ramsey. So I'm going to use this as leverage to get some time off of my prison sentence. And they end up telling the law enforcement what they heard, and it's nothing. Or it's something we already know. Or it's not prosecutable. Or it's not real. Like, we investigate it and it goes nowhere. And so there's no agreement ahead of time when you sit down where the government says, I will do X, Y, and Z. Almost never, unless it's a very special circumstance. Almost always, in fact, there is the qualifier from the government saying, this is not transactional. We can't promise you X, Y, and Z. Rather, you're telling us the truth because that's your duty to tell the truth. And later on down the road, it's up to our discretion. If that information is useful, we may recommend to the judge during your sentencing that you were useful, that you were truthful. Because you were truthful, it shows that you were in fact remorseful, and the judge should take that into account when they are sentencing you. But it is not something like you give me 10 pieces of facts that I can use against someone else, and I will knock off 10 years or 10 points off your sentencing guideline. It doesn't work like that. So a lot of you may be thinking, why would anyone talk? Why would anyone join the government? Well, that may be your only piece of leverage as the defendant, right? If you are facing a 20-year mandatory minimum or something much higher, or you are very low man on the totem pole of a drug conspiracy, but the number of drugs that can be tied back to you, because that's what you can do in a conspiracy, is so immense that your sentencing guidelines will be through the roof. What essentially will be life. But you're just a runner, but you know who the kingpins are. You have a huge incentive to turn on those above you, right? Considering you don't get killed. We'll talk about witness protection maybe another time. You really want to help the government in that instance, even if you don't have any assurances. And you're asked that at trial. Has the government given you any assurances that you're going to get something quid pro quo? The answer has to be no, right? Because you can imagine if the answer is yes, the credibility of that witness just becomes demolished. And there are so many factors at play in different investigations and different prosecutions that the government can't and shouldn't make that sort of promise to any defendant or any witness who comes in and testifies. But you can see why, even if you don't have like a sign, seal, deliver agreement in exchange for your testimony or your information, there are many instances where you are incentivized to give information to help your own sentence, but to also, it's a way of showing your acceptance of responsibility.
Yeah, and we'll often delay sentencings until after the trial of whoever it is we're targeting, so that no one can say exactly what you got. Like, if you testify and you can say, I have an agreement with the government, I'm hoping that the judge will take this into consideration, that I'm being helpful, but I don't know what sentence I'm going to receive. So we'll often delay the sentencing. The people who are sentenced last will often be the people who helped out, not the people who went to trial or anything like that. And look, I think it's hard to overstate the power of mandatory minimums. We talk about the death penalty sometimes. People understand how taking the death penalty off the table is such a powerful bargaining chip for prosecutors. Because you can say to a defendant, look, you plead guilty, you tell us what happened, you won't be on death row. You'll get life. In some states, You might even have a chance at parole, but you're not going to get the death penalty. Well, mandatory minimums are very similar. I'll give you an example. The law's changed a little bit, so it's not like this anymore, but up until a couple of years ago. So say you and a buddy go and rob a gas station with a gun. And then the next night, you rob another gas station with a gun. And then you get arrested. Well, robbing a business with a firearm and using it, brandishing it, is a 7-year mandatory minimum for the first offense. For the second offense, it's 25 years. So in the old days, what would happen is if you did that, you robbed 2 gas stations on 2 separate nights. If you were convicted of both, you would get a mandatory minimum of 32 years. And there was nothing that any judge could do about that. And that's assuming that's all you got. There could also be another sentence on top of that for the sort of substantive crime of robbing a gas station. Well, if you're looking at 32 years, and then if you robbed a third one, now you're looking at 57 because it's another 25 years. All of a sudden, if you've got something you can give the government, so the government can file that thing that allows the judge to sentence below the mandatory minimum, you're going to want to do that. And so there's strong incentives to join Team America when you're facing those kinds punishments. Mandatory minimums are a little out of favor these days. People like judges to have a little bit more discretion to be able to take facts into account. It's like everything else. It's a pendulum. Mandatory minimums will be back in favor in 10 years, but right now they're a little bit out of favor. But either way, they still exist, and they're still a pretty powerful incentive for guilty pleas.
So we've talked a lot about plea negotiations. So what about the judge? Because a case most of the time has been filed and is before a judge. The judge has read them their rights. There's been arraignment. Maybe they've presided over a suppression hearing. What does the judge have to do in a plea negotiation? The answer is absolutely nothing. And they can't have anything to do with plea negotiations. In fact, if you start talking about what was said in plea negotiations, the judge will stop you right away and say, you know that I can't have any role in plea negotiations. And that has to be between the parties alone. So this is when the attorneys talk to themselves and they do not let the judge know the back and forth of the plea negotiations. The only time it comes before a judge is when the defendant files a notice to change their plea from not guilty to guilty. And then if there is a plea agreement, the parties will file a plea agreement that is the final agreement among the parties, the final contract, but none of the back and forth. The judge doesn't know any of the, I offered 25 years, then they counter offered 15 years, and then we came back to 17 years, and then this is what we ended up with. None of that. And the judge cannot weigh in. They can't be an arbiter. They're arbiters for everything else in the case. But the parties can't call the judge and say, help us figure this out. We're kind of at an impasse. Help us figure out and mediate the plea agreement for us.
And different jurisdictions take this more seriously than others. There are certainly jurisdictions where the judges get a little bit more involved in plea negotiations than they should, including saying things like to the defendant, well, it's up to you, but if you're found guilty, it's going to be life. And then all of a sudden, it's like, oh, well, maybe we should go ahead and plead guilty. But in a lot of places, what they'll do, because, as Alice mentioned, I think at the very beginning of the episode, one reason you can appeal something is if, we talked about this in the Leo Schofield case, if your attorney receives a plea offer from the state and does not convey that to the defendant, that is something that can result in an appeal. So something some judges will do is they'll actually, at the very beginning of trial, before the jury comes in, they'll leave the bench and have the parties put on the record with just the court reporter there the plea offers that were made and the fact that the defendant rejected them. And then the judge will come back in without having any knowledge of the details and say, you've heard the plea offers, defendant. Is it correct that you rejected those offers? And the defendant says yes, and then you move to trial. At that point, you go ahead and go for the jury. So the judge has very little, or supposed to have very little involvement in the plea negotiations, with some exceptions that we'll get into when we start talking about the specific kinds of pleas that you can enter into.
So we'll talk about, in the framework, we know that there's lots of jurisdictions, states, locales, federal. We'll go with the federal rules on pleas because a lot of the state and local rules kind of adopt the federal rules. So if you're interested in reading along, it's Federal Rule of Criminal Procedure 11 that covers pleas. And what types of pleas are there? So there's essentially shorthand in the federal system, A, B, and C pleas, and you'll hear them referred to as such. And in most states that I've practiced in, they also kind of adopted that vernacular, A, B, and C. So what exactly does that mean? Well, two of them are mandatory acceptance by the judge, or the defendant gets to say, never mind, no deal. One of them is just a recommendation. The judge can reject the agreement, and the defendant is still hamstrung, can't take back their guilty plea. So this is a really important thing at the forefront. And before a plea is entered, this is made very clear to the defendant because this affects their rights after the judge makes their decision, whether to accept the plea agreement or not, and also what they decide to sentence them to, as well as appeal rights. So with that, let's talk about A.
Yeah, so an A plea is when you go in and you say to the judge, this is a 3-count indictment. He's going to plead guilty to count 1. We're going to dismiss counts 2 and 3, and we agree we won't bring any future charges related to this crime. So if you've indicted someone on a multi-count indictment, it's actually not up to the government alone to dismiss those charges. And we've talked about this before, how the power of the prosecutor decreases the further the case goes. So at the beginning of the case, the power of the prosecutor is at its ultimate level. They can decide whether to charge, whether not to charge. They can't be forced to charge. They can't be forced to bring anything to a grand jury. Once they decide to do that and seek an indictment and get an indictment, then their power starts to decline. So they can't, for instance, just get an indictment from a grand jury and say, you know what? Never mind. We're just going to dismiss this. They have to file something with the court. Now, it's generally understood that when you file something with the court is supposed to, barring some it's
Injustice.
obvious you were bribed, right? the court is supposed to grant it. But once you've gotten all the way to a plea, and now the defendant is trying to plea, now the judge has an interest in ensuring that the interest of the defendant are well represented, and the interest of the victim, and the interest of society in general. So let's say, and I think Alice might have had this exact case, that you had a case where you indicted someone on 10 different counts, and you wanted to dismiss 9 of them and have them plead guilty to 1, and that's an A plea. And then let's say the judge looked at that and said, but the problem is, if I do that, the maximum penalty for any 1 count is 5 years. And given all of this conduct that I'm seeing here, what if I think 5 years is not enough? What if I want to give them more? Well, if I do what you're asking, I can't give them more than 5. So I'm going to reject the plea agreement. I'm going to refuse to accept your A plea agreement. I'm not going to allow you to make this agreement to dismiss these counts. At that point, this plea agreement, which the defendant has entered into, they've already had a plea colloquy where they've admitted to the crime, like everything's already happened, and the judge is saying, I'm going to reject this plea. The defendant has 2 options. They can say, fine, I'm still guilty, I'm ready to go forward with sentencing. That's fine. Or they can say, well, then I withdraw my plea. And we can either try and work out another plea, or we can go to trial, but I'm not pleading guilty anymore.
So yeah, that exact situation happened to me month 1 on the job. And, we had worked through this, and it was exactly the sentencing issue, which we decided to dismiss 9 of the counts, and they were going to plead guilty to 1. And so when the judge rejected that plea agreement, they couldn't move forward with just pleading guilty to the 1 count. They had to plead guilty to all 10, or the judge wouldn't accept what they were going to do. And so because of that, you usually are working on these plea agreements right up to some deadline. And so trial had been set for about 5 days later, that following week. This was like a Tuesday. Trial was supposed to start Monday. No one had prepared for trial because we'd reached a plea agreement. It took a little while to hash out the parameters of the plea agreement, but 99% of the pleas that I have put before a court have been accepted by the court. So this is not the typical route that the judges take. And so the judge rejected it. The defendant scrambled, talked to the attorney, and decided, no, I'm not moving forward with my guilty plea. I do not want to change my plea, Your Honor, with thinking, okay, we'll go back and try to work out another deal. And the judge said, okay, well, this court has set this case for trial in 5 days, so we're going to trial in 5 days. And that was it. It was the fastest scramble I've ever done and this was like a 3-year-long investigation. This was not like some one and done, found a gun, we're good type of case. It was a long investigation with a lot of underlying conduct. And we had to find witnesses. I think we had like 24 witnesses who were all out of state that we quite literally had to track down, like with the U.S. Marshals and the FBI, sending them out to far-flung places, knocking on people's doors to sit with them on the airplane to bring them to trial to testify. And we went to trial.
And a lot of those witnesses didn't really want to testify either. they weren't
let's just say it wasn't
witnesses.
Clean hands all around.
Yeah.
The witnesses had interest not to testify, which is why it's so difficult to find them. But that can absolutely happen. So you can see in an instance like that how powerful the judge is. And both sides had no interest in going to trial. That's why no one had prepared for trial. And both sides had really wanted kind of the max for this particular defendant to be 5 years. But the judge said, I don't like this conduct. Heard everything you did. I want discretion. You know, when you stacked it to 10, I think it could go up to like 40 years. He was like, I might not sentence you to 40 years, but I want the discretion to sentence you somewhere between 0 and 40 years instead of somewhere between 0 and 5 years.
So how did the story end?
Let's just say that we went through a very intense trial, and it ended, well, before it ended, right before opening arguments. I hadn't slept in 5 days. The judge said, have y'all talked about plea agreement by any chance? And I was like, yeah, 5 days ago, sure did. Because the judge was like, are we really going to go to trial? Because here's the thing. The judge has to stop their entire courtroom when they go to trial. It backs up their schedule. It really puts them behind. It's a lot of work for a judge, right? And we were like, were we all in the same courtroom 5 days ago when you rejected that plea agreement? He's like, okay, I just wanted to make sure that we really have to go forward with the trial. Really, defendant? Because you seem pretty guilty. And we were all like, oh my goodness. And the defendant at that point was like, oh yeah, we're going forward. Went through the whole trial. The jurors took it very seriously. It was some complex stuff. I had to draw some charts and line graphs. We had experts, and it was intense, and they deliberated, and they took it seriously, and they did a good job, and they came back guilty on every count. And the judge said, you know what? This just seems really harsh. I'm going to knock out some of these guilty convictions, and I'm going to sentence you to about 5 years. I mean, every attorney on both sides was like, are you serious? We just lost years off of our life, and we could have avoided all this if, like, 1 week ago you just accepted the plea agreement. But you know what? It was the judge's prerogative. I'm not a judge. I don't get to decide, but that judge gets to decide.
There you go. You know, I always think it's funny, the Delphi case, people want to be mad at the judge. And everything the judge does, like I've seen judges do, that the latest thing is the judge is like, look, we're going to try this in this much time. And that's how long it's going to take. The judge that I clerked for, he had been a lawyer. He'd tried a ton of cases. He'd been a state court judge, tried a bunch of cases there. He'd been a federal court judge, tried a bunch of cases there. So he knew how long a case should take. So these lawyers would come in for their pretrial conference, and he'd say, how much time y'all think y'all are going to need for this one? And they'd say, well, Judge, you know, we talked about it. We think we're going to need 10 days. And he'd say, okay, well, we're going to get it done in 7. And that's the way it was. I mean, he knew how long a case should take, and that's how long you had. And if you were taking longer, he would start moving you along. He would start cutting you off. Like, he would tell you, you know, because a judge, as we've talked about, if a judge thinks the evidence is cumulative, he can exclude it under Rule 403. So if you had like 5 witnesses who are all saying the same thing, 3 witnesses into it, he'd be like, now, counsel, you got 2 more witnesses. Are they going to add anything that we haven't heard before? Well, you know, Your Honor, they're going to talk about it from a different perspective. So that's a no. Well, I mean, no factual things, I guess. Okay, well, then they're excluded. Can't keep them. Let's keep going, right? So you really had to be on it with him. Had to. And that's the way it is with judges.
And that's the way, absolutely. Have I ever told you the coda to all of this? So I went to prison for like another, I don't know, I think I was interviewing a witness or something like that. And I walked into the area because all, the women were kept separately. And this defendant was a woman. And I heard someone yell out my name. Like I was in the cell with like, they kind of have like a suite, like they have individual rooms, but during the day they get to all hang out. So it's like 15 defendants. And I heard this like, hey! And they said my whole name because, my name's on all the briefings and everything. I was like, dang, who knows my name in here? Like, that's not a good sign. And I turn around and it's that defendant. And she was laughing. She came over to fist bump me. She goes, remember when that judge did that to us? I was like, didn't know it was a bonding experience, sister, but okay.
Yeah. And we talked about this before. I think a lot of the defendants, they're obviously defendants who kill prosecutors. Like that happens. But I think most of them kind of get like, this is all, we're all in the game together and you got your role to play and I got my role to play. And they just, and she apparently was one of them. She kind of got it.
And look, so. I mean, it worked out for her. She got the amount she had agreed to. So like, it was all good. She was almost about to get out. She actually, it kind of looked like she was leading her own little cult in there. She was definitely Queen Bee. So like, she had it good in there. Not that it's ever good, but I'm just saying she definitely had like all the pudding cups, if you know.
She was really good at getting people to go along with her. That was one of her things.
Which was part of the crime.
That was part of the crime. So that's the A plea. The B plea is the only one the judge can't reject. So the B plea just says the government's going to recommend a sentence. It's not binding on the judge, but the government's going to recommend a sentence. It is binding on the government. So the government has to go in and recommend that sentence, and they have to do it wholeheartedly. So what you can't do, I've had this happen in a case, you can't go in and say, well, Your Honor, we're going to recommend the bottom of the guideline range because that is what we agreed to. But I got to tell you, if I had my way, if only we had the death penalty for this crime, Your Honor, then we would be seeking the death penalty. As it is, we're seeking a couple years, but this is definitely the most heinous crime I've ever seen. I'm just upset that my hands are tied. I guess, it's a good thing that yours aren't. And that's all we have to say. You can't do that. If you do that, then
they'd be ordering that transcript right away. I'd be like, that is, I mean, typically when you have a B plea, like you as the prosecutor go in and say, as it's detailed in the plea agreement, we agree that the appropriate range is as calculated by the probation office. And you sit down, you say nothing more. And then of course, the defense will make some impassionate plea about why it should be the very bottom of that, and no more. And it should be even less. They can argue whatever they want. And your position and what they get out of it is that you as the prosecution don't oppose anything they say.
See, I'm a bad prosecutor because I basically turn into a defense attorney at sentencing because whatever I say it should be is what I think it should be. So if I agree to the bottom of the guideline range, I'm arguing for the bottom of the guideline range. And so I'm like, all the reasons that this person doesn't deserve a day more. I try not to do
the job for the defense. I believe in each side having their roles, but I will not play dirty. I will not oppose them. You got to make your own arguments. I'm not going to make your arguments for you. But this leads us to C pleas, which is a twist on that. It's where both sides come in and say, we believe this should be the sentence, say 15 years. And if the judge rejects that, even if the judge is like, you know what, I think 14 and a half years is better, or 16 years, they won't go below that. Let's say they say 16 years. Then that's the same instance as the A plea where the defendant can say, nope, not going to plead guilty. So judges often do not, or in my experience, they do not like C pleas because remember with the A plea, why my judge in particular didn't want to accept it? Because they're like, I don't want to be hamstrung with just a 5-year range. I want to have discretion to, properly administer justice in the sentence. Same with the C plea. Judges don't like being told what to sentence their people. Doesn't mean C pleas are not used, but I would say in a lot of offices, they're disfavored for that reason, is that I've had them rejected. I've had more C pleas rejected than A pleas. And when a C plea gets rejected, it really is going absolutely back to the starting line.
And there's a really important reason why C pleas are rejected more often than A pleas, at least for now, until the Supreme Court screws it up. The judge can consider uncharged conduct, dismissed conduct, and even acquitted conduct So, for instance, if you go to trial on 2 counts and you're convicted of one and you're acquitted on the second one, at sentencing, the judge can consider the one you're acquitted of. Because at sentencing, the only thing the government has to show at sentencing for a judge to take consideration of it is a preponderance of the evidence, so that it's more likely than not that you committed this conduct. Because there's all sorts of other things the judge is considering as well, not just things you were charged with. So generally speaking, if you want the court to consider all this other stuff, as long as you can show by preponderance of the evidence that it was happening, then the judge can consider it. And it's sentencing, unlike in a trial where there's all these rules about what evidence can come in. Judges can essentially consider anything and everything about a defendant, both good and bad. So the defendant's mental health, drug history, that kind of stuff can go for the defendant in lowering the sentence. But things like, being an abusive spouse or having a long criminal history or even being charged with a bunch of crimes that you weren't convicted of can be something the judge considers. So an A plea doesn't really restrict the judge that much typically. It did in Alice's circumstance, but typically it doesn't. Because let's say you've got 3 charges. The max on each is, 20 years. You dismiss the 2. I mean, technically, every news story would tell you that person was facing up to 60 years in prison because technically you could run the max consecutively. That's almost never going to happen. Sentences are almost always run concurrently. So dismissing those other 2 counts really doesn't limit what the judge can do. And the judge can consider the fact that you did those things when deciding what the sentence is going to be. So the judge's hands aren't really tied that much. In a C plea, the judge's hands are absolutely tied, and no matter what the pre-sentence report shows, and it can show a lot of stuff that the prosecution didn't even know about when they entered into the plea agreement. No matter what it says, the defendant gets that sentence or the judge rejects it, and a lot of times what'll happen is the prosecution and the defense will enter into an agreement for a sentence because they think the guideline range is going to be like 24 to 30 months. So they enter into an agreement, a C plea for 12 or something like that, or maybe probation. I mean, that's a pretty common one for a low sentencing guideline. We'll agree to probation. Then the sentencing guideline comes in, and there are all these enhancements you didn't think about, and so the actual guideline range is like 120 months, like 10 years to something. And the judge is like, "What? You agreed to probation, and the bottom of the guideline range is 10 years? I reject this plea." That's what happens a lot.
Absolutely. So I know you've all heard this. Very few cases these days, criminal cases, go to trial, and that a high number of cases plead out. Plead out means they've pled guilty. In fact, the number always changes a little bit, but the most recent stats I saw from like 2022 is that 97% of federal criminal cases plead guilty. That means only about 3% of cases go to trial. I would say in the past 10 years, that's about right. 2 to 3% of cases go to trial on the federal level. I think it's a little hard to gauge all the different jurisdictions, but that carries true in probably most jurisdictions. It's definitely well over 90% of cases plead guilty. So while we all have a constitutional right to trial, as you can see in practice, very few cases actually do go to trial. And we've talked a lot about this, how there is this reputation, or I don't know, some view prosecutors as just wanting a notch on their belt, another conviction, another win. But we've explained, and this is not really that public facing, but everyone should know, that the prosecutor is a very important gatekeeping function of what cases to bring at all. So the fact that 97% of cases plead guilty says a lot of things. It could say a lot about maybe the disadvantages a defendant has. They have no choice, even if they're not guilty, but to plead guilty because of the disparities in sentences they'll get. But it also reflects the types of cases that prosecutors are bringing and the strength of the cases that they're bringing. And you are not seeing all the cases that never even make it to the charging phase. And so that 97%, while very high, and we'll talk about whether that's good or not for the justice system and for your constitutional rights, know that it is skewed because of the gatekeeping function from the very beginning in all the cases that are not brought. Not just because they're necessarily weak cases, but you have prosecutorial discretion. We talked about this with Rodonda Vault, the nurse, right, who accidentally ended up killing one of her patients. And we've talked about whether it was wise to even bring that sort of case, even though legally all the elements of the criminal charges were met. We face those types of cases a lot as well. So we have weak cases, which we decide not to bring, but we also have prosecutorial discretion when there maybe is a case where you can meet, all the standards legally, all the elements of the crime beyond a reasonable doubt. But there are other considerations as to why you shouldn't bring the case. Maybe a chilling effect on an entire profession or industry or policy. So these are just some thoughts on how high the number is, but I think it is absolutely worthy to have that discussion of whether that number is too high and what could lead to a number that high, and should it be lower, and would we be in a more just system if, say, 50% of cases went to trial?
Yeah, look, I think there's a combination of sort of academics and some judges who really don't like the fact that so few cases go to trial. And sometimes judges will talk about the trial penalty because you get a higher sentence if you go to trial. Well, of course you get a higher sentence if you go to trial. You're not accepting guilt. You're not admitting what you did. You're not throwing yourself on the mercy of the court.
But those are actual points calculated on your sentencing guideline. So it's a very real effect numerically on your sentencing guideline.
And it's interesting. There's actually a line of cases that say if you had a really good argument at trial, it's kind of funny. This is like a weird middle line of cases. It's like most people go to trials, they don't really have a good argument. It's just they're holding the prosecution to their burden. But there's like this line of cases that says if you had a really good argument, the judge should take that into account at sentencing and maybe not take as much credit away from you as they would otherwise. And what sometimes you'll see happen, which is a very effective strategy, is you'll have a defendant who's charged like 5 counts. They'll plead guilty to one of them. They'll say, you know what? I am a felon. I did have that gun. And that's illegal. And I'm going to take responsibility for that. But that 20 kilos of meth you found, that wasn't mine. That was planted on me. And I'm going to fight this. And so they'll plead guilty to the gun, and then they'll fight the meth, and then they'll lose. But they'll say, you should still give me credit for acceptance because I took acceptance for the gun.
I only laugh because that happens so often. I even had a defendant where like the gun was hidden in the drugs. And he was like, the gun's mine. Don't know where the drugs came from. And I was like, man, it's like all of it was stuffed in his underwear. It was like the gun was shoved in his underwear with like the drugs all like patting it to make sure, the gun didn't go off. And I was like, you got to accept it all, man.
Yeah. So, you have that. But I think the real problem you face if you're trying to figure out a way to force more trials, I mean, presumably your fear is, I guess there's 2 possible concerns. One is just the right to trial is so valuable that even guilty people should be going to trial more often. Okay, fine.
That was horrible to go to trial. Could I just say that? Almost every trial I've gone through, we call them slow guilty pleas because that's truly what it is. And your loved ones are watching the worst of the worst, and you're seeing people in your lives take the stand and say truths out loud because they have to. I mean, it is horrible for, I would say, your loved ones. Maybe you can like just turn it off on your mind and like disassociate as you sit through it, but it is a real emotional and mental load on your victims, but also your family members.
Like the Murdaugh trial felt like a slow guilty plea, and I think the Delphi trial is going to feel like a slow guilty plea, particularly when prosecution's putting on all these confessions. It's really going to feel like a slow guilty plea. So there's that. We should just have more trials because we should just have more trials. I think that's pretty weak. The other one is like innocent people are being forced to plead guilty because if they go to trial, they're looking at life in prison. Take my example of the stacked 924s. So you got the 7, the 25, the 25. Say you're accused of robbing 3 stores. It's 57 years in prison. Well, say the prosecution offers you 2 years on the robberies. We'll dismiss all the 924s, which are the gun counts. Well, it would be pretty hard. Some might call that a coercive plea deal, right? It would be pretty hard not to take that deal, even if you didn't do it, because the benefit to plead guilty is so great, which is exactly the reason that offered pleas exist. By the way, we talk about that a lot lately. I mean, the whole point of those is you feel like there's too much at stake for you to not plead guilty. You know the government has the evidence. You're objecting to it for some reason. For some reason, you're saying they're wrong, but you're accepting the best thing for me is to plead guilty. The problem is, if you take these concerns, it's easy to have these concerns. It's harder to figure out a specific way that you would deal with them and not punish all the people who are guilty, know they're guilty, and want to plead guilty. And it is very much in their best interest to accept responsibility for what they did and go ahead and get that process started. Like, how do you separate those cases out from these other cases? One argument is, at least mechanically, if you're trying to change the rules in some way, I think there probably is and should be sort of more of a burden on prosecutors and judges. We talk about this all the time, and Alice and I very much believe this, and I think it's an ethos that's sort of spreading. I think there was a time where it was not necessarily true that prosecutors took their responsibility to not bring counts as much as they did to bring them. I feel like that is changing. I think it's really important. I think prosecutors need to be very thoughtful about the charges they're bringing and the kind of indictment they're setting up and what they would offer. There are a lot of places where if you charge a mandatory minimum, you will not dismiss it in a plea agreement. That once you make that decision that you're going to charge it, you're not going to dismiss it. There's several reasons for that. Number one, you don't want it to be coercive in that way. You certainly don't want to just be bringing a charge for the purpose of a plea. That's one of the things we try to avoid, is intentionally bringing a count we never intend to take to trial just to force the person to plea. You don't want to do that. That's not something you should be doing. The second thing is judges taking seriously the plea colloquy. When I was clerking, my judge rejected a plea agreement because during the plea colloquy, it was very clear that the person who was pleading guilty did not want to plead guilty, was only pleading guilty because, and this is perfectly valid, but you can see how it would be coercive. He and his wife had both been charged. Part of the plea agreement was they were going to dismiss counts against the wife. So he's pleading guilty, so his wife's charges will be dismissed. And it was just very obvious that he didn't want to plead guilty. He was doing this for his wife. He's being asked whether various things are true, which constitute the elements of the offense. It's very clear that he doesn't want to say they are. And the judge stopped the plea colloquy and said, look, I'm not going to accept this plea because I do not believe this is a knowing and voluntary plea that this person is making. And that is pretty bold for a judge. It's not common at all. But it's one of the things that can avoid the sort of coercive plea agreement that you sometimes think about.
And that's a really good point. So these, at least all of the plea colloquies that I'm a part of, there are a very long list of questions, over 20 questions. It's been a long time since I counted them, but it is not in most courts a check the box sort of thing. The judges take it very seriously because they want the defendant, while the questions are all very familiar to the judge and the prosecution because we do it a lot, we recognize the defendant may be hearing these questions for the first time. They should have gone through these questions of the rights they're giving up with their defendant, but you'll see the judge really explain to them what it means not to be able to confront their witnesses at trial. And some people say, like, what do you mean by confront? What does that mean? And the judge will stop and explain things to them. And if they have to take a break and talk to their attorney, that happens. I've had plea colloquies take an hour or longer just to make sure that the defendant truly understands the things that they are giving up, because they should understand the things that they are giving up before they plead guilty. And so I would just say it heartens me whenever I do a change of plea, because of how seriously everyone in the courtroom takes it and wants to make sure that there's understanding, that it's not just a bunch of legalese being thrown at the defendant. I can't talk for every courthouse, but the ones that I handle, at least, that is the aura in the room. We want to make sure there's true understanding, not just a checking of boxes. So there you have it. Everyone understands plea agreements now, right? But there are really large esoteric questions about plea agreements. We'd love to hear from you about them, because I think it's worthy of debate, especially because the number of pleas have gone up over time. They fluctuate some, and they fluctuate from jurisdiction to jurisdiction. We tend to only see the really high-profile cases that go to trial. And so it may be skewed, and that's why the 97% number might actually seem very high to you, because in my mind, wow, every case on on TV is going to trial, right? That's not the case. But that also doesn't mean you have to have one of those blockbuster cases that grabs national attention in order to go to trial. We have people who go to trial all the time in our courts, and you are allowed to do that. But it is a very weighty question for the defendant whether they do actually want to go through that process. So, with all that, Brett, is there anything you'd like to add about pleas before we answer some questions?
I think I've had enough, Alice. Please, let's move on to questions.
Please. Finally, he makes a pun like 100 episodes later.
No, I mean, look, it is an interesting subject. A lot of you have asked us to cover it. If you've got other questions we did not address, we're happy to talk about them. There are other kinds of pleas we could talk about. Talked a little bit about Alfred pleas. Probably that deserves its own case. Nolo contendere pleas, no contest, same thing. There are other things that can happen to you. So probation violations have their own little court systems and ways of doing things, and you can plead guilty to those in a way. And there's a lot. There's a lot. And I'll say this, probation violations are one of those places where you'll sometimes see people try and not enter a plea, do like a Nolo type plea. And I've had judges say to defendants, I don't accept those in my courtroom. So you've either got to plead guilty or not guilty. And that's the thing. Like, I think it's surprising to people, and I keep going back to Delphi just because I see the way people react to the thing the judge does. I think people just don't have a good understanding of the authority and the power a judge has in their own courtroom and how much flexibility there is within the law. And that's why every case you watch will be different.
I mean, we joke as lawyers that a district court judge is the king or queen of their fiefdom, right? Because they are one judge versus like an appellate court where there may be 3 or more judges who sit on a panel. Think about it. An analogy I think might be helpful for people to think about is a teacher in a classroom. While there are rules and regulations and school policies about how the teacher needs to hit certain things, certain metrics for their students. For example, only so many tardies, or, they have to be able to count and subtract certain things by a certain time in the year. But incredible discretion is given to a teacher because they're actually there with the students. They see things that big policy, Congress can't see with each need of each child. And they do actually have incredible discretion in how to run their classroom. And so they're not questioned every single time they discipline a child, send them to study hall or send them to detention, or say, no, I'm not going to let you go to the bathroom for the 10th time right now. You're not going to get a hall pass. Sit down, finish, and go do X, Y, and Z. We give teachers a lot of that discretion in their own classroom because the environment necessitates it. Same with a courtroom. So much is happening. It's all real life. Nothing is formulaic. There are real people in there constantly moving and breathing and changing minds and speaking. There is no set of rules and no set of check boxes that can apply to every single courtroom. And that's why our judicial system allows really an incredible amount of discretion to district court judges within certain parameters that are, of course, subject to appeal, review, etc. in certain circumstances.
Okay. Let's do some questions. This is from PJM. PJM says, in business, we use metrics to measure performance of people and processes. Are there any metrics used to evaluate prosecutors? If there are, what are the good measures and which ones drive bad behaviors? So, think about that for a second. So if you're in business, what is the metric? Usually it's pretty straightforward. It's profit, right? Increase in profit, output of goods, whatever you want to call it. The problem with prosecutors is you really don't want to put too many metrics on them. You don't want conviction rate to be the metric because then you're encouraging either not pursuing tough cases or cutting corners to get the convictions. You don't want, the number of indictments they bring to be it either because then you're encouraging them to bring indictments that aren't necessarily, solid cases. I don't think you want it to be cases that are overturned either, because once again, the thing about the law is there's a lot of gray there, and there are cases that prosecutors feel strongly about and feel like they're on solid ground, and they make good arguments. I would hope that when you guys listen to our stuff about the Supreme Court, we do Supreme Court arguments, you see how good the arguments are on both sides, and how even if you think one side has the better side of it, they're good arguments, and people can argue in good faith, and one of them is going to end up being wrong because that's how the law works. And a lot of times you have that with prosecutions, where even if a case gets overturned, and getting a case overturned is a big deal. We don't like that, and that is generally not a good thing, but it's not really the way you want to judge it. And so many of the things, how do you take into account all the cases the prosecutor doesn't bring, or the cases they decline because the evidence isn't there?
Or the complexity of the case, right? Like for every one really complex fraud investigation that we pursue and bring, we could bring quite literally maybe hundreds of felon in possession cases or pretty easy drug possession cases. Like drugs were found on them. They were literally smoking the crack pipe. Those types of cases that are like one instance, not a lot of investigation. You could bring a lot of those cases, but it may take you 3, 4, 5 years to investigate a very complex conspiracy that may be international in nature and with hundreds of players. So that particular prosecutor may bring one indictment in 5 years, whereas their neighbor who's focusing on like drug crimes may bring hundreds. Does that mean one is 100 times more productive than the other? No. And also, you don't want those incentives. So we are lucky that we don't have certain metrics we have to hit. Now, a lot of DAs, elected positions, they run on those sorts of metrics, right? And you'll see kind of incentives at the time of an election year, for example, that they'll pardon someone or dismiss charges against someone that we find wildly guilty because there's a lot of public pressure to do so. Or they bring really harsh cases against people who maybe shouldn't be charged that strictly because they want to appear hard on crime during an election year. So, I mean, it is a difficult question. It's an important one to think about. But before you kind of layer on metrics that may have a positive effect in other industries, recognize that there are a lot of potential negative externalities it may have on prosecutors and criminal law.
It's a good question, though. Good question.
Great question.
And I hope you guys will keep giving us the tough ones. Those are always fun to do.
Is there an easier one?
Do you want an easier one?
I'm just
kidding. I can find an easier one.
They're great. We love these questions. By the way, if you leave a 5-star review in Legal Briefs or the Prosecutors Podcast, you get to leave a question, and we will answer it just like we are doing now.
Exactly.
Are we done with questions?
Do you want me to find? I mean, I can find another one.
We're good. We're good. We've gone for an hour and 15 minutes. We are good. Well, guys, I hope this has been enlightening. If you have any additional questions about plea agreements, plea colloquies, the role of judges, the role of prosecutors, and the right to go to trial, we welcome these questions. We did this episode because you guys asked about it, so keep coming with ideas. You can reach us at prosecutorspod@gmail.com, on social media, on Instagram, Facebook, X, and even TikTok at prosecutorspod. We love hearing from you guys. Reach out, and until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. I was listening to Stolen, but there's so many episodes about nothing.
Yeah,
because there's not much information. I get it, but it's
right.
I'm 6 episodes in, and I'm like, there's nothing.
Yeah.
It's like a lot about her own trauma.
Right, which is great. I mean,
Which now, I do understand why people like our show, because it's they're recounting facts, but that's it. There's no thinking about what it means.